Good afternoon. I'm here to present on judicial appointments because no one seems to be talking about it at all these days. My conception on this particular problem, it's not going to be doctrinal or historical or analysis of any of the past cases and so on, because I don't want to hang myself with Argo in the room. He's the authority on these things and he will be discussing some of this. My main point of view is an economic point of view. And what I mean by that is I'm going to look at how incentive compatible these different systems have been, and therefore what sort of outcomes they are likely to produce. A second issue, judicial independence is a really large subject, and I'm going to restrict myself only to judicial appointments. There are a lot of other related issues such as how long the tenure is, post-tenure qualifications and disqualifications, salaries, promotions, so on and so forth. This paper is going to be very specific about the way we appoint members of the judiciary. So what are we looking for in a judicial appointment system? This is from the Constituent Assembly debates, where Ambedkar says that the goal is dual. One, you want a system of appointments which is protected from executive interference, and at the same time, you want the judiciary to be competent in itself. It's almost as if he spoke last week about what the problem is, but this is essentially the problem I am attempting to resolve in this presentation. What is judicial independence? Simply that one is free of fear and anticipation of any punishment or reward related to the particular instance of judicial decision making. So it's the most basic definition or description of what judicial independence is. We have had three systems of appointments, of judicial appointments in this country. The first, which was the dominant system for about 43 years, is appointment by clause. That's what I've dubbed it. It's basically appointment under clause 124(2) and article 2171 for high courts. That predominantly gives primacy in appointments to the executive. The second system, which is from 1993 till present times, is appointment by collegium. This collegium is made up only of judges. The third system, which the new government has attempted but has been struck down, so it's not actually been implemented, is the new commission, which is very controversial. It's the National Judicial Appointments Commission, and that we call appointment by commission. So I'm going to be evaluating these three different systems of appointment. And I'm evaluating it on the following margins. There are two types of systems, systems that are robust and systems that are fragile. What do we mean by that? When I say robust, I mean robust to shocks, both internal and external, any outlier to the system, right? The reason I have a wine glass for the fragile is you typically tend to handle it with care. Any system that only requires handling with care is a fragile system. The moment someone doesn't handle it with care, the system breaks down. So when we're thinking of systems in political economy, we want systems to be robust and not to be fragile. So that's one point of distinction. And what are the sort of shocks we're talking about? One set of threats is external to the system, one is internal to the system. In the specific case of judicial appointments, external threats are from members of the executive. They can be from many other sources, but that's the main key controversy. And internal threats are from senior members of the judiciary. Right? These are the two main types of threats that we want to evaluate on whether they're robust or not. So we'll start with the first system. This is appointment by clause. Now, what Article 124(2) and 2171 essentially do is they give the power of appointment to the president. It rests primarily with the executive. Now, both these articles have the word consultation in them. It's supposed to be exercised in consultation with the Chief Justice of India, and in the case of high courts, with many more. Now, there's no clarification procedurally on how this consultation must take place, whether that consultation is purely advisory or whether it's binding, so on and so forth. This has been a problem right from the beginning, since the 50s. So at some point, what consultation meant procedurally was never clarified. And what this consultation really means. Because of the weak procedural drafting, it ended up being taken forward by convention, by some sort of like gentleman's agreement. You know, the Prime Minister, Chief Justice of India, Law Minister, they sit together, they figure it out. And that's how these conventions developed. Now, the problem is, the moment there was an outlier, which in our case is Mrs. Gandhi's second term, the whole system collapses. So when we speak of judicial independence, you had the Keshwanand Bharti case. In that, Justice A.N. Ray gives a verdict which is favorable to the government. Justices Grover, Shelat, Hegre give a verdict that's unfavorable. And the very next day after Chief Justice Sikri retires, the three are superseded and Justice A.N. Ray is rewarded and the other three are punished. This is your textbook definition of interfering with judicial independence. A few years later, in ADM Jabalpur versus Shivkant Shukla, which is one of our more embarrassing moments, the same thing happens. Justice H.R. Khanna gives the dissent, which is unfavorable to the government. He immediately gets superseded. Justice Beg gets rewarded, and he's made the Chief Justice of India. Even worse, I think, than just looking at the Supreme Court, you have 16 transfer cases in the High Court. Instances like the Kuldeep Nayyar case where Justice Rangarajan is moved from Delhi High Court to Guwahati, so on and so forth. Lots of instances of that. So the system of, you know, respecting convention and respecting some kind of agreement that took place between the executive and the judiciary completely broke down. So we know system one is fragile. It is not robust. It hasn't proven to be robust to this kind of outlier. Now there are two types of errors that have been made in system one decision making or in any decision making. One is type 1 error and type 2 error. I have this funny picture up because I am personally always confused between the two. So type 1 error is a false positive, right? Something that shouldn't have resulted that way. That's what they tell you is the result. So they tell a man that he's pregnant. They tell a woman who's quite obviously looking pregnant that she's not pregnant. Now, what does this mean in terms of judicial appointments? Type 1 error is judges who should not have been appointed or promoted were in fact appointed and promoted. Type 2 error is judges who should have been appointed and promoted were not appointed and promoted. So just sticking with the Supreme Court appointments, this is not the sum total of type 1 and type 2 errors. Just for instance, Justice Ray and Chief Justice Ray and Chief Justice Beg's appointment as the Chief Justice would be your type 1 error, and Shellad, Grover, Hegre and H.R. Khanna would be your type 2 error, right? There are a lot more, and it's very difficult to parse through and actually figure out the sum total of errors in judicial appointments. Now we have, because of this type of system which was not robust and completely broke down, the judiciary, both the bar and the bench, decided that we need a more robust system. So they come up with this appointment by collegium system, starting with the second judge's case in 1993. And the third judge's case actually brings in a lot of the procedure for this. What do? They create a collegium. The collegium is only members of the senior judiciary, a few more for high court appointments. And the end result is that the consultation with the Chief Justice, that is the Chief Justice who's representing the collegium, is now binding on the President. Okay? That is Justice Verma's interpretation of the word consultation in Articles 124.2 and 2171. So now we have a system where the judiciary is going to primarily be responsible for appointments. Now we know how well that has worked. They don't have a secretariat. They don't have a system to help them vet candidates, right? They're already backlogged and overloaded. So it's not clear how they're really picking justices for judicial appointment. And they have also not been very transparent to come out and tell us what the method of appointment is going to be or what the criteria is going to be. So I think it might be eeny, meeny, miny, mo, which might be an improvement over some of the other things that they're doing. Now, what about type 1 and type 2 error? Now, this system also has type 1 and type 2 error. But it's worse than the first system because we only know the very worst cases. So type 1 error is something like Justice Sen and Justice Dinakaran when it's revealed only when they're at the point of almost being impeached, right? We're not able to figure it out sooner than that. And we have no clue what the type 2 errors are because they won't let us, they don't record minutes to their meeting, they don't reveal it, they don't let us know who are the candidates for consideration and who was appointed, how many votes within the collegium were cast. So there's a complete curtain behind which this takes place. So this doesn't mean that there aren't as many type 1 and type 2 errors, simply that we don't know them, which is probably worse. And then recently, Justice Chelameshwar has revealed to us that the way they are conducting their proceedings is really not up to par with the third judge's case. They don't follow procedure. They don't record minutes. They don't send them to the executive. So you'll have situations like, then it is agreed 9-1 that we say that our previous vote was unanimous. This is really how they are conducting judicial appointments meetings, which is incredibly dangerous. Now, what this does is a lot of junior members of the judiciary are deferring to senior members, right? They're afraid to speak because it's literally their boss who is there to evaluate them for their next position. There's a lot of lobbying from members in the High Court to members in the Supreme Court to attempt to get a spot. So the system is not proving to be very robust to internal threats, nepotism, corruption within the judiciary. And I can't give you good empirical evidence because we have absolutely no idea, because that's how the system is set up. Now, what's happened is both systems have proved to be fragile on some margin. One, to external threats, which is the first case. It was relatively robust to internal threats. The second, to internal threats, it's relatively robust to external threats because they don't involve the executive in any way. Now, any debate on this subject, which has been executive versus judiciary, I'm afraid, has been trading off their preference for is the external threat better or is the internal threat better. I think judges, even on their worst day, are better than the executive on their best day. You know, that kind of argumentation is taking place. But I think it's only a matter of time before we see a really terrible situation, even within System 2, which is what we want to avoid. Now, the NJAC attempted at the concept level to fix this problem. And what they did was they tried to bring in a commission which had members both from the executive and the judiciary, and also 2 independent members to really make it seem like everything is above board. Because the trend seems to be to involve civil society in everything. So they had a collegium of 6 members, and the eminent persons will be appointed by Leader of Opposition, Prime Minister, and Chief Justice of India. Now, this was struck down almost immediately. It's not been implemented. So I can't tell you if it's been robust or fragile. I can only tell you if it's vulnerable to the same problems that the other 2 systems are vulnerable to. Now, what are the problems? I mean, there are lots of problems with the NJAC system, but I'll point out 3 critical problems. The first is eminent persons. And my fear with eminent persons is not the typical fear that Salman Khan will be one of the eminent persons. That's not the problem. The problem is, even if you get someone really honest and really public serving, the problem is they have no skin in the game. It is not clear to me that they have any interest in opposing the interests of the judiciary or the interests of the executive to therefore sufficiently oppose whatever is going on in the collegium. So what we need is we need people to check the interests of the dominant players. And eminent persons, if they are very self-interested, will have their own agenda. If they're not self-interested at all, might be lame ducks. It might go either way. I don't think that's a robust system. Second, which is the biggest problem, is delegation. The first problem is a lot of the things that are there in the 99th Amendment have already been, should have been there, have been delegated to the NJAC Act. As we know, it's easier to repeal and amend ordinary legislation than a constitutional amendment. Now, what is worse is the ordinary legislation through Section 12 power to make rules further delegates an enormous amount of power to the Commission. So there are a lot of rules, procedural rules, that are completely unspecified or underspecified. For instance, in a 6-member commission, we don't know who has the casting vote, right? They don't seem to be able to count. We don't have any procedural safeguards such as a minimum quorum requirement. Does that mean the Chief Justice of India can call the meeting all by himself, put the rules in place and vote and say it was unanimously passed like the New Yorker cartoon? That seems to be a possibility. I'm not saying it's going to happen, but that's not a good way to draft these rules, right? You have a lot of other criteria which has been delegated. The power to form rules. So the commission will form the rules that are going to regulate the commission's proceedings, which is your fundamental error, right? That's just a mistake that you don't make. You need the rules to be in place beforehand. Things like the criteria for the suitability of a candidate, a lot of leeway has been left for the commission to decide that criteria in this internal meeting. Now, with delegated legislation, Parliament doesn't have to even pass ordinary law to amend it. It just needs to be laid before Parliament. So there's virtually no oversight on any of these rules. So in one sense, even though the NJAC seemed to be a good idea, I'm sort of happy that they have struck it down, because it forces everyone to go back to the drawing board and rework what needs to be done with judicial appointments. This is where we're at right now. And what we realize is that this is not sufficient to realize Ambedkar's goal. None of the three systems have checked both the boxes that Ambedkar wanted checked. So what do we do now? I'm bringing in some economic analysis, and the two big benefits of economic analysis, which I think have been missing in the current discourse on this topic, are the following. First is methodological individualism. What that simply means is the assumption that it's individuals who act and individuals who choose, and not institutions or groups. So this is not about the judiciary choosing something as a whole or the executive choosing something as a whole. It's members, individual members with their interests and their agenda who are making the choices. The second is that individuals pursue their self-interest even when they're in public office, not just when they go to buy apples and oranges or cell phones, right? Always, individuals are pursuing their self-interest. This self-interest need not be narrow, but it is a self-interested individual. Now, the power of these two assumptions, what it does for us is, instead of trying to create circumstances where we require benevolent individuals to handle a particular situation with care, we can now try and design robust institutions which will actually channel individual interest into some kind of self-interest, just the way the market does, right? So what we need is, we need to take the self-interest, we need to align it better with social interest. And in the paper, I've tried to give some principles that can help us do that. I think from page 11 to 15, I've enumerated some specific procedures that may improve on the existing procedures. I don't want to go into them in detail. I'm happy to take it up in questions, but I'll go over some principles. First, the Indian framers already thought that people might be self-interested, which is precisely why the Constituent Assembly didn't want the Chief Justice of India to have a veto or an individual decision on this matter, right? We see the same thing in James Madison. This is the American experiment, which is, we need to counter ambition with ambition. We need to counter opposing interests with one another so that we will get a more robust system. The reason is, at the constitutional level, you can't have God come in and adjudicate on these disputes. You need individuals to check each other's power. How do we do that? The first is composition. I've come up with a composition. There could be many different versions of this. My version of the composition is, we need to replace the two eminent persons with people who actually have skin in the game. And my suggestion is, one should be the leader of opposition in the Lok Sabha, and the other should be a member from the Rajya Sabha who is elected by more than 50% of the votes of the House. Now, the reason for these two specific individuals is as follows. The leader of opposition is obviously going to check whatever the government is trying to do. So it's a really good check for the executive, and they're also elected officers. That's the additional benefit. The second is, today's opposition is tomorrow's government, which means that the leader of opposition can make decisions on a time horizon which are much more long-term and not just about immediate political urgency. The member of Rajya Sabha is crucial because the Rajya Sabha is not pro-cyclical in elections to the Lok Sabha. Right? It changes, the composition changes every 2 years. Very often you have a Rajya Sabha where the ruling party in the Lok Sabha is not the majority party in the Rajya Sabha. So you're likely with this election to get an additional counter who is not just from the Lok Sabha and also representative of the states. And if we want eminent persons so badly, apparently there are a lot of eminent persons in Rajya Sabha, including 12 nominated by the president. The Rajya Sabha is free to vote one of them with 50% of the House. The second reason why I have this composition is it's staggered in its appointment. You never have this particular appointments commission all coming in at the same time and being dissolved at the same time, which means everyone's discounting factor, that is how they value to the present over the future, is different, which means not everyone is going to make short-term decisions all at the same time. So it's not all going to go to hell. The quorum should be Chief Justice of India plus 4 members. You need a fairly high quorum to decide something this important. I don't think this needs more explanation. Now, this is the important condition, the unanimity condition. I believe that this commission with a quorum of 5 needs to be unanimous in its voting, because Supreme Court and High Court justices should not be appointed on a whim. That's the first reason. The second reason is you can't have any kind of executive interference or tyranny of the majority if you have a unanimity condition, right? Everyone has a vote, and thereby every single person has a veto. So if your original goal is robustness of institutions from executive interference, this is the way to get it. If your original goal is you want to appoint justices very easily, then you should do away with all these requirements, right? The second is this kind of voting rule will be robust to external and internal threats, because you have different composition of people who will check each other's interest. And finally, only in an economic sense, Pareto improving decisions might be made. What that means is everyone will be better off and no one will be worse off with these decisions, because you need everyone's consent to go forward. Now, to strengthen the unanimity requirement, I have also put in clauses for disclosures. We need, another reason not to have eminent persons is there's no requirement for them to disclose anything, whereas Lok Sabha and Rajya Sabha members must disclose all their assets, criminal records, so on and so forth. So one is the individual members need to disclose all their assets, spouses' assets, etc., for a period of 5 years after they leave the commission. Second is the voting should be immediately disclosed. The reasons must be written and presented to the president and disclosed after a period of 5 years. That protects the privacy of the candidates, but at the same time, we need a reputational cost that will force people who are voting to actually vote their conscience, or at least face the full cost of whatever they're doing. So if anyone is highly likely to hold out, everyone will immediately know they're holding out. The cost of holding out increases, and therefore it's less likely to happen. Now, what about holdouts? First of all, we have good experimental evidence that in economics that holdouts are less of a reality than what is predicted in economic theory. So theoretically, you can have holdouts, but you end up having far more consensus even amongst veto players in reality. Now, dynamic decision making, especially because it's a constitutional situation, we're not just making a decision on who's appointed. We don't know what are the benches they are going to sit on, how that is going to help the individual people in the future, so on and so forth. It's all very, very difficult to predict the entire course of any appointment that you might support or veto. So in these dynamic cases, holdouts are less likely. Holdouts are more likely in a zero-sum game, when you are splitting a fixed pie in a one-shot game. And this type of a commission does none of that. It's a repeated game, it's a dynamic effect, and it need not be a zero-sum game. I'm almost done. Third is, if you have open voting versus secret voting, you're less likely to have holdouts. I'm just going to rush through the next couple of slides. What you will have instead of holdouts is vote trading. Vote trading is, we'll support a few of your candidates if you support some of our candidates. And while that might sound like a terrible idea, if you just pause and think about it for a minute, it's actually an excellent idea. It gives you a procedural framework within which consensus can be built. Consensus doesn't mean everyone has to believe exactly the same thing. It simply means we can compromise and sometimes agree to disagree on certain choices. So vote trading actually helps us build consensus. Second is, it will increase the diversity on the bench. And I don't just mean diversity from high court and region and caste and all the things that the Supreme Court already does. I actually mean diversity in thought and jurisprudence, which is completely missing from the court right now. And finally, what about collusion and corruption? I believe if you have strong disclosure requirements and you have strong post NJAC disqualifications, that will help strengthen any kind of potential corruption. So right now, the biggest problem threatening judicial independence is that justices are appointed for all sorts of executive positions immediately after retirement. Right? That's the worst form of corruption that has seeped in. So anyone who is serving on this kind of commission cannot take any post for the next 5 years. I want to end here not because these are the only ways to strengthen such a commission, but this is the type of system that will increase robustness, and I'm sure we can keep adding to that list, as I hope that you all will.